Hello, everyone, and welcome to this legal business webinar sponsored by OpenText. We're taking a detailed look at how to reduce legal spend and minimize risk today with a discussion titled Early Data Reconnaissance, Reducing Cost and Risk. My name is Joe Boswell, and I'm a senior member of the Legal 500's in-house legal research team. I'll be moderating today's discussion. Before we get started, a couple of words about the format. The discussion is based on 5 topics, each taking about 10 minutes. In order, the topics are determining the scope of an investigation, AI in early case assessment, privacy issues, the influence of COVID on investigations and cases, and finally, predictions for the future. If you have any questions, put them in the chat function, and I'll try to put them to our panel at the end of the discussion. I would like to quickly remind everyone that the opinions expressed are those of the individuals themselves and not necessarily reflective of those of the organisation they're a part of. But with that out of the way, I'll spend a couple of minutes introducing our panelists. Daniel Eisen is Director, Litigation, Investigations and Enforcement at Barclays and has a wealth of experience in all these areas in the context of personal, corporate and investment banking. Sean Upson is a partner at Stewart's Law, who specialises in complex commercial high court and arbitral disputes, with a particular focus on banking and finance disputes and financial fraud cases. Asla Yildiz is head of legal at the Data and Marketing Association UK, formerly a data and privacy and security lawyer, cybersecurity lawyer at Taylor Wessing. And last but not least, Gareth Meatyard is sales director for Northern Europe at OpenText. He'll be providing his perspective on recent developments in early case assessment and investigations from the vendor side. That's everyone on the panel. So now let's start with our first topic, which is to do with determining the scope of an investigation. And my first question is for Daniel. So yes, Daniel, as an investigations officer at a large corporate like Barclays, complex beast, how is it that you determine the scope of an investigation, or what sort of data you're going to collect and how to gather it, etc.?
Thanks very much. I think as you said at the outset, obviously what I say today will be my best attempt at insights that I've picked up from general experience in the industry. So working with multiple law firms, technology vendors and LPOs, as opposed to specifically attributable to my work at Barclays. But if we take the question, I think I'll start by thinking about this at its broadest level. I do litigation as well as investigations, and I think that the techniques are broadly similar across both. So what I say is relevant across the piece. And I know that Sean is going to come on to some more specific elements of the case assessment process, specifically looking at issues in dispute or under investigation. I'm not going to steal his thunder on that. I'll focus more on the institution perspective on what are likely to be the most costly aspects of an investigation or disclosure exercise in litigation. And specifically, I think that would typically be the document review stage. How can we ensure that the data collection and review is proportionate and adequately scoped to reduce the cost? The challenge we often face, I think, is that there are clearly competing priorities at the outset in one of these matters. For example, a smaller custodian list and date range is clearly something that would be cheaper from a cost perspective to get into, and also more likely to comply with data privacy requirements, which is another topic that I think is going to be covered later on in this session. The flip side is that if you go with those priorities, you may find yourself incurring more cost in the long run, as multiple collections could be needed. And you may also have knock-on effects of that. So for example, you might have inconsistency of your review team if you have to do multiple collections and review cycles, and you also may struggle to identify your most relevant documents early on. So there are clearly issues, not just in terms of cost, but also quality of your work product. There are obviously significant implications for the successful outcome of whatever your matter is, whether it's an investigation or a litigation, if you don't get that initial scoping work done correctly and adequately. I think in terms of the techniques that I've seen to get that right, that they're probably, dare I say it, not that innovative at the moment. And we'll come on to where the innovation is, I think, probably later on in this discussion around AI. But obviously, you've got to get the information onto a platform before you can actually apply that AI. And I think that the collection techniques probably aren't as innovative as the later piece. The way that I've seen this addressed, I guess you can either be very granular in terms of identifying the issues that are in your investigation or litigation and scoping collections on an issue by issue basis, or you sort of go more broad and you focus on the big picture and the threshold questions. And I think my experience is you do need to focus on those threshold questions rather than applying very granular keywords at a collection phase. That broader focus, I think, will typically generate more efficiencies such that you don't have to do multiple collections, have inconsistency of reviewer, and take longer to identify your key documents. And I think just probably one last comment that I'll make on this, without straying onto subsequent topics that we're going to get to, is to say, in terms of keywords, I think my experience is that keywords are obviously something that the industry has focused on in the past in terms of really getting to the heart of an issue. I think we're going to talk in the next question about the AI tools that are available, and there's so much more now that people can do that is not dependent on keyword searching. So I think in terms of techniques at this early scoping phase, I would say not necessarily a great thing to be too focused on very granular keywords with complex sort of, connectors and things like that. That they don't need to be the focus, because the keywords don't have to be your main tool for the search. And I think we'll come on to that. We'll come on to that in the next topic. And I'll probably pause there and hand back, I think, to the next speaker.
Thanks, Daniel. Yeah, Sean, what's your perspective on sort of efficiently determining the scope of the investigation?
Yeah, I suppose I'd break that down into three parts. One is sort of process, one is some early investigation, the third is costs. In terms of process, we tried to put all cases through an assessment process really early on. And Stuart started doing that originally because we were doing a lot of third-party funded cases, or cases we funded ourselves. And by definition, they need to be case assessed at the start. But what you quickly saw was that those techniques were applicable to all cases and should be applied to all cases. And where it came from was that it doesn't matter how complicated the case is. You know, you can have a £400 million Financial Services Markets Act dispute, but it probably comes down to two issues. It probably comes down to reliance and defendant knowledge. Or you can have a fraud case and it might have 100,000 documents, but it's going to be won or lost probably on about 10 or 20 of those documents. So we try to put in place a process to identify what are those key issues right at the start, and then assess them. When a case comes in, do we have the documentary evidence? Do we have the witness evidence? Do we have the expert evidence? Is there a crucial issue on which this is going to lose? And it's an iterative process as well. Every time a case is won or lost, we go back and say, what was the fault line on which that case was won or lost? Let's apply it back to the next new case that came in, try and learn from that, and try and learn how most efficiently to get to the key issue in cases right at the start. And the outcome of that is that you can then say very quickly, certain cases should be settled, or they're not cost effective to take forwards, or the ones that do go forwards, you can very quickly say, right, those are the key issues. Let's focus on them, not focus on everything else. Second part of it is doing some early targeted work. We try to get into the key disclosure pretty quickly, and we'll come on to sort of technological techniques for doing that in a minute. But in a reliance case, can we see the claimant's investment models? And that's going to be a key document. In a fraud case, the financial crime team will use the technology to find the clusters of documents that are around the conspiracy or the fraud. So try and do that quickly. If it's a competition case, can we get to the expert evidence very quickly? Because those cases can often win or lose on the econometric evidence. So we have an in-house econometric expert who can look at it very quickly and say that one should proceed or shouldn't proceed, as the case may be. And then the third part of that is cost, trying to put cases into cost budgeting right from the start. And it's well and good to investigate a case, get 6 months down the road and go, oh, well, now we know the issues, let's budget it. By then, you've probably got such spend on the case that it's very hard to bring it back into an efficient model. So we try and put it into cost budgeting straight away. And again, that identifies the cases that are not cost effective to go on. But those that do go on, it allows us to actually then manage it to a process on those key issues and keep all the costs down. So those are the three things. It may sound like it actually increases cost, and it might do at the start, but it massively saves cost in the long run doing those.
Great. Yeah, Gareth, you're obviously you're looking to try and minimize the cost for the people that you provide services for. So we're going to get into some of the sort of technological side of things and how effective they are from the client's perspective in the next topic. But yeah, I was just wondering how you think, how you can sort of what your tactics would be for keeping costs low, and when you're determining the scope of an investigation.
Thank you, Jeff. So very similar to the perspective there from Sean, in that I think for a long time we've been trying to reduce the cost of the page turning exercise at the end of document review and disclosure, and there's a lot of industry that is concentrating heavily around the cost of that particular review. But notwithstanding, in my previous tenure, I've been looking a lot at data growth within organizations. When you consider somebody like Barclays or another institution is likely to be doubling their data footprint every 2 to 3 years by reducing the page turning exercise by the time it reaches Sean, you're fighting a losing battle. And I think here at OpenText, we've certainly recognized that if all we ever do is improve the TAR process and reduce the costs at that end, we're really just stemming a tide that's not going to be effective long term. To that end, we had a lot of experience with our clients whereby we're working at that point of collection and that early data assessment to understand what is pertinent. And recently, or more latterly, we've been introducing services to that external counsel and also internal counsel can leverage for what we call recon investigation, the ability to do that early reconnaissance, whether with just people who aren't going to turn every page, but are going to look more specifically to the facts and the issues of the case, or whether that's the individuals and their skills or the technology to augment them. And as you say, we're going to talk a bit more about how technology can do that. But very much so bring the ability to gain access to more data earlier in the process at a more economic point, and then not turn every page, but look specifically around the issues and the matter at hand, and are there supporting or conflicting points of view within the data set without saying, right, we now have to review everything based on the keywords as per the DRD or the CNC. So that's something that we've been pushing with our clientele more latterly in the US, and is starting to come over into European soil with great applaud. And it is that whole bring people in sooner. Don't do this at the point of disclosure. Try and understand the data before disclosure. And I think there's been a reluctance to this because of the way that we have historically had organizations in our sector set up. And we're set up to support counsel to receive a bulk of data and look at it quickly and efficiently. What typically hasn't happened is drive these processes earlier to nearer the collection, enable the corporation to see more data at a better value point, and do a more poignant view of that data to understand case strategy moving forward and what may later go into disclosure. And happy to discuss as well some of the technology facets that we can bring in as we go through today's session.
Okay, all right. So we'll move on to the second topic now, which is to do with AI in investigations and early case assessments. We've had a bit of an introduction into it there from Gareth, But I suppose here, I think it's best for us to try and work out where the technology is for people that are actually working with it. So again, I'd like to start with Daniel. Yeah, I mean, how do you see the technology? Where is it at, and how useful is it? Is it completely necessary for you nowadays? Yeah.
Sure. I guess a few points to cover on this, some of which will probably be music to Gareth's ears on the tech side, some of it less so, but some food for thought, hopefully either way. I think at a high level, it is definitely the case that the technology has developed greatly over the last sort of 5 or 6 years, such that certain forms of AI are clearly being routinely used by most people in the industry. Specifically, I think the one area that's probably the most widely used is predictive coding. So it can be used in different ways, but certainly the reviews that I'm seeing are all using predictive coding to do one of two things. Firstly, to sort of identify the subset of documents from those that you've collected to which you actually subject to review. So you can use the predictive coding to give you relevancy percentages. It's obviously an algorithm that's learning as you review the data set, and you can cut your review once you reach a certain threshold level of relevancy. So that's one way that it's supporting us all in the industry at the moment. The other area, which is potentially even more interesting, is the way that it enables you to identify your key documents more early on in your review. So the algorithms can push your relevant documents, having been trained. Once an initial coding exercise has been done to train the algorithm, you can push your relevant material to the top and hopefully help you identify your most relevant material early on, and therefore improve your early case assessment. Where I think there's room for improvement, and I'd be interested in other people's views on this as well, is in the embedding of the more sophisticated uses of the AI tools. So there are more sophisticated options out there, but I'm not yet seeing them being used consistently across the industry. Others will probably talk to this in more detail, but for example, there are tools in the market now applying really great visualization techniques to large data sets to support with the early case assessment. So for example, they can do things that linear reviews obviously could never do, even at the output, at the end of a linear review. For example, cluster maps showing who's communicating with who, at what times, potentially where, word maps showing you the common terms across the data set, or standout words. And my experience of these platforms is that they are very intuitive and usable. They actually don't require a huge amount of training, unlike predictive coding, which I think was quite difficult for the industry to pick up and did take a period of time. The bit that, and actually just adding to that, it's probably true to say that because they use visualization techniques, people can sort of see what they're getting and are quite enthusiastic about these new tools, as opposed to the inherent nervousness in adopting coding, where the algorithm was sort of behind the scenes and you didn't know what was going on. The flip side that I've experienced is that these tools do require practice. It's kind of difficult often in real time in a complex investigation or litigation to adequately deploy these new tools. You have to have a very clear idea of where your use cases are, what they look like, such that you can deploy them in the time pressure of a big case. And so the sorts of areas where I think these tools are particularly useful, and again, some of this is still, we're not yet able to apply these directly, but you can use it to fast track something like a privilege review. So to help you identify what the privileged documents are. You can use them to speed up a second level review. So to tell you what's there that the first level reviewers have got, to enable more qualified lawyers to filter the relevant material quickly. You can also start to use it for things like generating chronologies, which is an amazing way to really fast track work that was done by numerous lawyers over a long period of time. So the tools, I think, are getting there, and there are some great options, but unless you focus really on what the deliverables are, I think there's still a tendency to use these things to sort of supplement a traditional review, and perhaps not yet save the costs and generate the upside that we'd like as on the client side. And I'll let you know, again, others may comment on how fair or unfair I've been there. The last observation I'd make on it is that there do seem to be a lot of competing products in the market, and there's some great technologies. I'm not yet sure anyone has everything under one banner. So I'm not throwing down the gauntlet there to Gareth or his competitors. I guess it's just when I was reflecting on this in preparation, it's an observation that perhaps that may be impacting on the sort of pace and consistency of adoption of these tools across the market, because everyone's using slightly different ones, and perhaps not everything is in one place yet. But as I say, an observation that may not be shared by others. And I'll pause there for other thoughts.
Thanks very much, Daniel. Yeah, Sean. So obviously you're using the technology from a slightly different perspective, or maybe to a lesser extent than Daniel. Yeah, what are your views on where it's at? And
yeah, I mean, I've got to say I agree pretty much with everything Daniel just said there, and picking up something Gareth said earlier about using these tools earlier and getting them close to the data earlier. I agree with both of those comments. I mean, our perspective is that AI and data analytics can be very useful, and we see it in two particular circumstances which Daniel touched on there. First is where you're looking at case assessment on a fraud or a financial crime investigation. I mentioned it earlier, but getting the software in there very quickly, getting it over the documents, getting it over the data, and as Daniel mentioned, identifying the clusters of documents that relate to that fraud are incredibly important. And to give an example, a client might know that fraud has happened. It's obviously going to be financially related, but it may not know the extent, it may not know the fraudsters, and it may not know the code words that are being used to communicate that payments are illicit payments being made. And the analytics can throw up clusters of documents that show they're using the code word Smarties every time they send some kind of illicit payment. And it can get you to the key data really quickly in those investigations. But again, picking up what Daniel said, it's getting used a lot on the fraud side and the financial crime side, less so perhaps just on the general commercial litigation side. And I think you're absolutely right, Daniel, it should be used more. Then the second aspect is on the disclosure side, where it's been a very powerful tool. I've worked on cases with hundreds, thousands, millions of documents, and the thing that Daniel was describing of getting a first pass review with human reviewers, working out relevance, then applying the analytics to do the rest of the review to identify the key relevant documents is really powerful. And in my experience, it's at a high level of accuracy. It's very defensible. The other side, it's hard for the other side to attack your document review when you've put it through a process and that process has been agreed by the court and by the other side. They can't really quibble with what is then being thrown up, and it's very cost effective. But again, echoing what Daniel said, there's a real reluctance to use these tools sometimes, or to use them piecemeal rather than try and use them as the tool to start with. So I think they're really useful, but we need to use them more.
Right. Ashley, so we've heard from Daniel, who's in an in-house role, and Sean, who's in private practice. And I know that you've worked in both. You're in private practice until quite recently. What do you feel the attitudes are towards technology in these two different sort of worlds? And what are your experiences with them? Specifically in relation to investigations or litigation.
Yes, thank you. I think our challenge is the same as an in-house or private practitioner. So when it comes to the investigations and you need to look at lots of documents and analyze them and bring a solution, I think there is no difference between a private practice or in-house. And therefore, the usage of the AI or new technologies for that should be similar or same. But because of the understanding of the technology and the culture of the organizations vary. They don't take it as a same, for each company. When I was working at Canon as a technology company, they were more maybe technology focused, and others may not be, focusing on that. And also how they're tackling with the problem is different, because if you're working as a private practitioner in a litigation department, this problem is your everyday problem. So day to day, you are actually facing with it. So you will focus on maybe the technology more, or you will be searching for the results even more. But when you are in an in-house department, you may face with this problem, not every day, but time to time, and then you may be actually subcontracting to a party that actually they are solving that problem to you. But overall, my experience is our problem is the same. So what we are doing is to bringing a justice to something. So we are trying to prove something for an individual or an organization. And for that process, we need to have some help from the technology, as well as our processing activities, our policies should be clear, because that will give us a shape of how we are going to act, in terms of this problem. So there are loads of similarities, but different approaches in private practice and in-house.
Right. Yeah, I suppose we can't really let this topic go by without allowing Gareth a right of reply to some of the things that we mentioned earlier. Yeah, were there anything that people have said there that you'd like to speak on, Gareth?
I'd like to pick up on a couple of points, and I think Daniel and Sean's observations are absolutely spot on. And I think in response to Daniel with the predictive coding, if I look back to what we were doing OpenText way back in 2015 with the De Silva Moore case, when we introduced predictive coding to the market, it was hard to get it embraced at that time. There was a lot of convincing to be done. I mean, we've subsequently had cases where I've seen things just proceed with predictive coding and sort of ask for forgiveness later type approach, and not run into issues. But I also believe that again, we're talking about what's happened downstream, and predictive coding has to be the default position going forward. Otherwise, it's just going to be untenable. But more to your point of bringing those techniques earlier, as I previously mentioned as well. I think we're almost at the pain of the way in which a market has grown and progressed. And some people used to come and get data out of your networks. Some people used to turn that data into something that maybe a review platform could read. Then people put that into a review platform so that you could codify the documents. Then somebody thought we should have some analytics. And there are a lot of approaches that tend to put 2, 3 or more technologies into that cycle. And that's certainly where I'd like to say that OpenText, we've taken a very different approach. It's a common platform all the way through. If I look from our law firm partners, they will often use us as the review platform to gain access to that sort of early review and analytics, right through to technology-assisted review, predictive coding. But our corporate clients are taking the same platform much earlier in the process, and maybe connecting it to the email systems directly, maybe connecting it to file systems directly. This vision of a discovery lake, whereby if we want to throw some keywords in and see what it does, I haven't had to wait for the collections team to get hold of that yet. Take it over to counsel to decide whether they're going to bring it to OpenText or another vendor. Very early in that cycle, you can work with counsel, say, well, this is what we think we're going to go for keywords. How does that work? And see what's going to happen. Furthermore, because we're at that end of the cycle, the AI that you're describing is already available. So some systems will help drag the data out of your network. Some systems will make it text readable. Other systems then do the analytic. Our approach has been to completely join that up. If I'm bringing it out of the network, I already have the text, and I'm already seeing the influence. I can start inferring that this might be privileged content right from the outset. It never has to make it through to do too far down to review for disclosure. It all goes over to the disclosure team as preordained privileged data. And to Sean's point, picking out the very specific pieces of information. The fact that the analytics are there, and we're not just using keywords. If this, and this item are of interest to me, what else happened around that date? That shouldn't be something we wait for to happen at the point of preparing the disclosure and the first level review. We really do feel it's disjointed the way that the industry has assembled itself and the products that are there. Every product is there for a very specific reason. And we just feel that we're in a position now to offer our clientele the ability to, literally the entire, as we used to call it, the EDRM model, the discovery reference model, left to right. Now, how many times have you seen that model with this vendor here, this vendor here, this vendor here? Well, that's not really a great way of looking at the process. The end result is we want the 20 documents that do or don't settle that case. Do I want to go through 1 million documents with outside counsel? Not really. And I don't think, Sean, you'd want to go through that level of documents if you could avoid it. And I'm sure, Dan, you wouldn't want to provide outside counsel that amount. So why don't we use those tools a lot earlier in the process? And I think that's the challenge for business today, is understanding that different people within the organization touch the process at different times with different biases or opinions or expertise or experience, and trying to educate IT that it is all right to touch their systems, and educate the investigations team that the analytics tool can do the data extraction and denisting and all those technical things, and then the analytics tool could be used in-house, and maybe outside counsel would appreciate being able to have a quick look-see before such time as it's being handed over to the site to really look at case strategy, and then finally a tiny subset goes over into review and still gets TAR applied to it. And to Sean's point, there's a bit more cost in doing that. There's a bit more proactive cost in being prepared to work that way, but the downstream savings are ginormous. Now, if we're spending 30k here to save 200 or 300k here, it's a worthwhile exercise. Well, normally we start with a much slighter on-ramp, if you will, because it's, well, the guys will spend a couple of hours to collect the data, they'll throw it over the wall, but then you're getting a 500k bill over on the right-hand side because you didn't spend 30 in advance. And those are the sort of economics that we're now looking to work with, where our influence isn't to how many bodies can we put around a problem, or how many gigabytes and terabytes can we charge you for. It's how can we get you from this end of the process out into Sean's team with the best advice possible and understanding the data you need to work with. And that's where hopefully we're going to change the way that corporations, inside counsel, and the private practice can work together in the future.
Fantastic. So the next thing that I thought we should tackle is the issue of privacy. Obviously, you're gathering vast amounts of data, hundreds or thousands of individuals, personal communications and all that. I suppose the best person to start with is Asli, who works for the Data and Marketing Association. So yeah, what are some of the risks here when you're in terms of infringing on privacy issues, and how are the best ways to mitigate these?
Yes, so we have got a lot of data, but when we talk about personal data, obviously that brings us to another level of this problem, because everything is almost personal data. So if you think about email address, so all these documents that you have got there, email addresses of people, and yet we need to analyze more data because there's a personal data element into it. Or there are investigations now, with the new legislations coming from data subject access requests. So everything that a company holds is maybe, according to the legislation, is a personal data. So it actually increases the amount of data that you need to go through, even for the DSR, the data subject access request, or any other investigation, when we put the personal data element in. So the difficulty with this, obviously, you don't want to go through millions of documents and you want to reduce the cost, and we're discussing this. But I think the legislation, GDPR and UK GDPR, offers a solution to that, because coming to Gert's point, so closer to the collection point, what we want actually, what we advise to organizations that collect the data cleverly in a way that data collection point, you need to collect less data, which is, we are talking about the data minimization, and data retention, you need to actually retain data in a systematic way. So you need to have policies in place that how you are retaining that data, how long you are retaining that data is very important. And then when we come to deletion of data, we actually advise people, if you don't need certain data, please delete that data. So if you've got this concept in place, which is explained as privacy by design, privacy by default, then you will have actually you will be having a solution in the end, because you will be applying all these principles to your processes or policies. So you won't have millions of data to investigate. So I always advise the organizations. So if you are having problems with the data subject access request, you probably didn't put right policies in place and real and applicable policies in place, or your processes are not clear and transparent to people that they have problems with your applications or usage of personal data. So my thinking on this, if our challenge is the same, for all organizations, for law firms or others, and when we add a personal data element into it, why don't we actually look at what the legislation is suggesting us and thinking from the privacy by design, privacy by default point of view, and think about this this data collection, that how can you reduce the data your organization have, and then move to the ed tech solutions, the solutions that the technology actually require. And so if you have got less data and if you're using the right technology at the right point, you probably have got a less of a problem, because you will have a faster and less costly investigation. And I just want to add that this is not only organizations' problem, private organizations or law firms' problem, it's also regulators' problem too. So they are investigating large matters that is affecting so many people, and they need to go through so many documents and so much data. So if they also apply this at the governmental level or regulatory level, I think we will have maybe quicker solutions to regulatory issues, maybe actually getting better results than what we are having at the moment. So combination of these two principles, privacy by design, privacy by default, and using the technology, I think is the solution for privacy issues.
Fantastic. Okay, so for the next topic, I thought it would be odd for us to not try and at least tackle some of the effects that COVID has had on investigations and data collection. Obviously, people are using different ways to communicate with each other. So I thought maybe we could discuss about how that's affecting different companies. Yeah, if I could start with Sean. Obviously, you deal with a lot of different cases. I was wondering how COVID has changed the way you go about retrieving data, and any other trends you've noticed.
Yeah, I mean, it's affected investigations quite a bit, but strangely in quite a uniform way. So clients, whether they're US, UK, continental European, wherever, they're kind of reacting to the challenges of COVID in much the same way. The first and the obvious one is we're on Zoom at the moment, and that's become Zoom, Teams, etc. has become the default tool for investigations, interviewing witnesses, taking client instructions, talking to experts, and so on. And it's almost tried to go, oh well, we're all used to Zoom now. But what these platforms have particularly done is they've speeded up the investigation. Actually, in the past it used to be that we'd have an issue that would involve say a pharmaceutical company. It might have an issue involving the accounting function, the legal function, and then some of the technical experts. And you suddenly have a meeting with 15 people, which would just be unwieldy. But within Zoom, you can actually pull in the experts you need for the bit of meeting that you need. So that has speeded up that sort of investigation process. Similarly, screen sharing is just incredible. I mean, in the past, we used to send traveling drafts of documents around, people within the law firm and people within the client, and it might take 12 emails to get a document done. Now, get it up on the screen, get it amended, get that note out there of what we're finding, and then you've got some work product that can be used very, very quickly. And then, of course, file sharing and collaboration platforms have really taken off. Everybody's got used to now just uploading their documents as needed, and that's been a real bonus to us. The other part of it is remote court hearings. They've been incredibly successful. I think we did the first trial after lockdown, and it was multi-jurisdictional. It involved the Bank of Kazakhstan and BNY Mellon, and it worked really well. But what it showed was you could make it work, and for clients, it was incredibly valuable because they could join the hearing very easily, in and out as they need to, not waste a day traveling into court. Key witnesses who are needed for the evidence wouldn't necessarily have to give up a week flying in from the US. They could just attend on the day when they give their evidence. So at the front end, the investigation is being speeded up, and at the back end, it's being speeded up, and it's all becoming much more sort of efficient. I suppose there are two limitations, though, and actually they come back to the same issue, which is that sort of personal contact. The jury's out as to whether, when you're interviewing a witness or somebody suspected of having done something, whether it's okay to do it like we're doing it now, or whether you need to be in the same room. And people have mixed views whether you need to be in the same room to look them in the eye. And so that's held people back a little bit. And there's a slight reluctance to investigate in those circumstances. And a couple of investigations I've seen have been put on hold. Conversely, we're acting for a sovereign state, and they nonetheless insisted that everybody fly out to do the investigation in the country, which meant a private jet, which was great fun. But, again, it was that personal contact thing that was required. And then settlement. Again, people think that a settlement discussion to try and resolve a dispute or an investigation needs to be face-to-face. So I've seen a situation where clients literally were walking around Paternoster Square because they didn't want to do it by Zoom. Everything was closed. So literally walking around the square, having their discussion. But, on balance, I think the technology and COVID has made us adopt the technology. The technology has been an absolute bonus. And I think it's going to stay with us after COVID is gone. That's my view.
Yeah, thanks. Ashley, what sort of trends have you noticed as the DMA been sort of keeping tabs on certain things that are interesting in this area?
I mean, if you're asking about our members, yes, some of them, of course, doing, using the technology, and as Sean mentioned very clearly, that using the current technology for communication, for investigation, for any other purpose is a must at the moment. We have no other way, and they are increasing, and they are discussing, obviously, how can we actually make this sustainable so we can actually continue acting this way, because it's cost efficient, time is important for them. They do definitely consider using the technology more, not just for investigations or reducing the cost for the data reduction, but for other businesses as well. And at the government level, as we are discussing with the government institutions and European institutions as well, they are definitely looking at how can we use the technology more efficiently, and how can we achieve the results that we want to achieve faster and more efficiently in the near future and after COVID. They're definitely in their agenda, and we're discussing this, how we can do that. Also Brexit effect, that we need to create our own bubble, I guess, that we need to actually be more data aware, and how we're using data in the UK to show the world that we can do this, and we are doing, and we are good at using data, and we are using data to increase the business, the growth, the economical growth, and rebuilding the economy after the COVID. So these are the conversations that's happening right now, and this is directly related to the technology.
Gareth, as a legal tech vendor, you're dealing with a lot of different clients. What has changed over COVID, in your opinion, if anything?
I mean, it was a challenge for all of us in all industries, wasn't it? I mean, one day we're sitting there with our colleague next to us and water cooler moments and beers after work, and the next minute we thought we were having a bit of a jolly at home for a few weeks. Here we are a year later, and yeah, we've had some challenges to overcome. I mean, very early on for us, we were involved with a multinational requirement, going back to sort of our early topics of collection. Some of the issues that we were being faced with, well, we've just furloughed half of our staff, and a third of the custodians you want to collect from are no longer available. And no, you're not going to come into our offices, and we're not going onto our servers. So there were a lot of challenges that we faced initially. And as Sean says, these mediums, the sort of the teams that we use ourselves, and Zoom and other that others use, gave us that facility to work with internal IT teams, work with in-house counsel, to get people together and say, right, we have to get hold of this information. How are we going to do this? Working with HR to overcome how are we going to get the data from these people that you furloughed. And in very short order, our collections organization had put together standard process for remote collection, and then for quarantine collection for when we had to go to site. So I don't think it was a case of okay, we'll put our feet up and we'll wait, this isn't going to happen. It was the courts and the regulators were still expecting the input, and we were expected to proceed. So that was our first learning, and we found that we had to increase the capacity of our collections team to support our law firm and commercial clients in the processes they had. Furthermore, at the other end of the spectrum, when you're entering into review, we're used to looking at review facilities and seeing lines of desks and secure doors and no telephones in here, and all of a sudden those individuals aren't allowed to go and sit in a room together. So again, we had to adapt extremely quickly to a remote review facility. So providing the option, and laptops as they are here today with their cameras built in, being able to provide review and knowing that it was Gareth sat in front of this screen, not Joe sat in front of this screen, and that I was sat in front of the screen, in which case I can see the documents. That there's a privacy connotation there, but also just a general security question being had, who is in front reviewing. So again, we had to adapt our review capabilities to not only make sure the data wasn't traversing to those remote points, that they were handled in the cloud, in jurisdiction, within the territorial bounds, but also that the remote connections couldn't pull that data locally. Cameras couldn't be used to take pictures of that data, no local download. So yeah, there was quite a bit of adjustment. And again, I just feel quite fortunate. I'm part of a much larger entity at OpenText. It's not just the legal tech organization here. We are an enterprise information management vendor. We are leaders in various IT quadrants outside of legal tech for things like collaboration and cloud hosting and so forth. So having the backup of the company, we took 15,000 people home over 1 week and we can maintain complete operations. So quite fortunate from there, but we're able to share that experience, those skills and those abilities with our clients. So yeah, it's been testing, but I've not seen anybody yet that's gone, we didn't manage through COVID. I think the only thing we probably haven't managed is that beer with our friends after work, and I'm sure we're all looking for that to reconvene in the not too distant future.
Absolutely. Yes, so the final topic is where we're looking to the future, basically. Daniel, I know you had a couple of opinions as to what might be going on in the future of internal investigations. Do you have any thoughts you'd like to share?
It's a big question. So I think, and I guess there's a few points I could make here that kind of follow on from some of the discussion that's just been had. That there are some areas where I think we can still hope that things get better, and maybe I'll touch on a couple of those. And these are tricky because I think a lot of the technology that will improve the way that we do things does already exist. It's about it becoming more accessible, more user-friendly, kind of more embedded in the day-to-day of what everyone's doing. So the type of AI tools that we were talking about before, the use of the techniques that are already in the marketplace is one example. Probably the areas that we haven't talked about, the first one that I would mention that's interesting, certainly for big institutions and particularly in financial services, is around audio analysis. So for investigations and litigation as well. I think there's still a way to go in terms of the technology to transcribe audio calls, enable search functionality of all of that. So that's kind of an interesting watch space. I think we can certainly do a lot more now than we could just a few years ago, but there's still more needed in terms of the pace at which you can obtain audio transcripts and reliable audio transcripts, and search those. The other area, which I think follows on from something that Sean was saying, and a number of interesting comments around how COVID has impacted. I like the Paternoster Square settlement discussions. I'm aware remote mediations have been are being used and actually have turned out to be a lot better, perhaps, than people anticipated they would be. Who knew that just hanging around the law firm in a room and not seeing the other side wasn't actually that much to miss. But I think the area that Sean touched on that's really interesting is around the kind of add-ons to the video conferencing functionality that we're all used to. You mentioned the document sharing and the screen share functionality, which is excellent. I think, and I'm really interested to see. It's not that it impacts so much the kind of the nuts and bolts of an investigation, but at some point I think we really need to get off email for things like document iterations and turns. And I think the next bit of technology that I'm interested to see is that greater functionality in terms of institutions being able to interact with law firms, experts, and anyone else, any other stakeholders involved in investigation or litigation, and not have email as our golden source for iterations of documents. So you get that kind of audit record in a standalone piece of software. People can dip in, immediately see the most up-to-date version, track who did changes, etc., without kind of trawling through their emails. So I think that's an interesting one, probably broad to kind of legal practitioners generally, perhaps outside of law as well. But that's one that I'm interested to see how it develops, and perhaps our experience in the COVID times can help fast track that as a use case.
There was a lot of people nodding there, so I think you were correct on that one. Yeah, Sean, where do you see this area going in the sort of midterm?
I've got to say, I was nodding over the email point. I mean,
Yeah.
Wow. I mean, if we could collaborate without 50 emails on the topic, it would just be fabulous. I mean, one of the areas that I think is very interesting is it's kind of a combination of, you have AI systems in the corporate world now that can do some basic due diligence, and you have emerging AI systems that can look at statistics relating to judges or statistics relating to barristers. And this may be a long way out, but whether you can start converging that and applying it to a litigation space and actually get systems that can look at a data set and really start to understand and sort of not necessarily predict the result, but almost kind of look at that data set and say, these are the issues you should be thinking about. I think you should talk to this witness, or I think you should be looking at this issue, or just automating that process even more. And it will start with smaller disputes that are more repeatable, and then I think it will go from there. And I think it's a long way out, but I think that would be really exciting.
Yeah, Ashley, what sort of legal tech would be something you'd really wish for in the future, or do you have any other sort of relevant predictions?
No, emails actually, Daniel. Thank you. So many emails, and if we can reduce the data, I think we should start from the emails, right? So conversations are going you know, on an email or a chat basis. So we're putting a lot of information there as well, and investigating those is a nightmare. So yes, hopefully this year showed us, I think, that we can communicate via video. We can communicate, you know, without writing to each other in any form. Therefore, we can actually use maybe that as a starting point, and so how we can improve this technology, communicating without writing, as people would do. You know, people would normally talk to each other, but in the offices, we were even next to each other, we were writing emails. So that should stop, that should reduce. And also, I think we need to use the existing laws and legislation, I'm talking for the privacy point of view here, for our benefit. So if they are suggesting that you can do the data minimization, you can actually use privacy by design, you know, start thinking about technology at the beginning, how you're processing should be, how you're actually collecting data. Maybe you don't need that data. So if you start actually adopting this with a technology, you know, you don't need to do it much, but they're asking you to collect only maybe 3 data and you got that. Maybe that will be a way to go in the future. So I would like to see more of that, using the existing legislation, indicating us to future technology that for our benefit, rather than actually being a block for lawyers or anybody else.
Absolutely, yeah. Yeah, so that leaves Gareth. So short of revealing any trade secrets or anything like that, what are your predictions for where the technology might be going in the future for helping people get ahead of the data?
I think it's good to have prediction come true, and if Sean and Daniel are really needing, and Sasley, you're needing something to help you away from the email, I'm pleased to be able to tell you I'll contact you after our panel today. So you know, online collaborative document control is something that is part of the broader OpenText family, and that can minimize that for you going forward. So love to have that conversation with you. That approach already exists today, and I suppose where yours would be a technology prediction and request, mine really is a people and process request. You know, we're making great strides with technology. Some of the things that we do from a technology standpoint, you know, if you compare it to 5 years ago, even 2-3 years ago, we're streets ahead. You know, we've taken things like TAR and taken that back to the information about data. So understanding metadata and being predictive about the metadata, not just the documents themselves. Did you think you'd be in a position already today whereby by coding documents as part of a review, natural language processing might find other institutions or organizations or actors in the content and start raising those as people you should also be looking at? So I think we're already pushing a lot of boundaries with regards to the AI that's in the platform. My hope and my wish, and it's something that's been in my career for the best part of 20 years, I came from the ILG, the information lifecycle governance end of the discussion, more so than the EDRM and discovery model that we're in today. And Asli, very much working with you keep in too much, get rid of the rubbish, only retain what you should, and document retention is something that's very, very close to my heart. And I think if we can bring each of the stakeholders to the table that understands the implications of over-retention from what is counsel going to end up with their hands when a case happens, over-retention from we've got personal data we should never have had in the first place. Now, it costs to store it. It costs if you over hoard it, and the ICO or DMA have decided you shouldn't own it, and it costs when counsel finally have to review it and it's not relevant. So I would my prediction, but my wish would be that we can get each of the stakeholders through the journey, from IT that love their shiny new things, through to legal counsel who, I'm sorry to say, I know Sean sometimes slightly more conservative for obvious reasons on the speed of adoption. But if we can get both ends of the cycle talking through the middle, and my nirvana would be a discovery lake, a corporate intelligence that understands what's in the information of the corporation themselves, that can be used to measure the retention, decide whether it's pertinent to a case, and decide whether we should have it at all within our businesses would benefit not just the legal process, it would benefit the obligations that an entity has, and at the same time, hopefully, really surface higher quality data for the business to be working upon. So it benefits all parties, not just at the point of litigation or regulation, but also having better quality work product that the business can reuse and repurpose. So not a prediction of technology per se, Joe, but certainly a wish for a better way of working in future, and something we'd love to engage our clients on in all our facets, from the regulators we support to the corporations we empower, and the council that we provide facilities to today.
Fantastic. So that's brought us pretty much nicely on time to end the webinar there. So I suppose the only thing to say is thank you very much for taking the time out to contribute to this. I've had a very fun time moderating it. So just to remind everyone, this has been a legal business webinar sponsored by OpenText. This will be available online shortly if you'd like to watch again. But yeah, thanks again, guys, and speak soon.